The U.S. Supreme Court has been hearing oral arguments in a number of explosive cases, including the freedom of web designers to choose what version of marriage they will adorn through their work, plus cases dealing with Joe Biden's executive order transferring student loan debt from borrowers to taxpayers, and Harvard's race-based admissions policies. At the same time, Elon Musk's Twitter revelations shed light on politicians influencing social media policies. Also, we're learning the shocking backstory of the collapse of the FTX crypto exchange, and peace negotiations in Ukraine are stalled. We will discuss these issues and much more in today's episode of Independent Outlook. Hello, everybody. I'm Graham Walker, coming to you today from the Independent Institute in Oakland, California, right across the bay from San Francisco, where we try and bring you an independent take on the issues of the day. And as always, I am joined by my friend and colleague, Dr. Williamson Evers. Dr. Bill Evers, welcome. Good to see you.
Welcome.
Just as a reminder to our friends, Bill Evers, longtime fixture at the Hoover Institution, and then in recent years has joined us as the director of our Center on Educational Excellence here at the Independent Institute. And Bill, we are sure glad to have you.
Thank you.
So we have a lot to talk about today, and hopefully our friends will follow us and maybe contribute some of their own thoughts afterwards. I wanted to mention this fascinating case at the U.S. Supreme Court. I think it's called 303 Creative LLC versus Elenis, in which, and tell me if I've got this right, Bill, on the basic facts, in which the state of Colorado is enforcing an anti-discrimination statute, at state level statute, against the creator or owner of a web design company.
Right.
She does wedding websites, which are a big deal nowadays.
She's doing this prospectively. She brought the suit because she wants to do this. And she doesn't want to be punished at the outset.
Yeah, well, she's probably wise, because otherwise she could really be zinged financially and in other ways. But apparently the state thinks that her business is or would be in violation of their statute because, given her religious beliefs, she does not want to create websites that would adorn, beautify, affirm same-sex marriage, because she says that's against her Christian witness. That's how she thinks of it. So the state thinks otherwise, and the 10th Circuit, U.S. Circuit Court of Appeals apparently agrees with the state of Colorado for the moment. It's gotten appealed, and the U.S. Supreme Court is taking it up. So what's the underlying issue here, do you think, Bill?
Well, it's not, as the plaintiff has brought this, it's not really a freedom of religion issue. It's a freedom of speech issue. Mm-hmm. Obviously, the woman's religious beliefs underpin what kind of speech she wants to engage in, but she's saying that this is forced speech. This is compelled speech. So her attorney, I think this is interesting, has pointed out that it's not just same-sex marriage that she would not do a thing for. If two couples that she knew of, if a couple that she knew of were married to other people and had an affair and then divorced them and decided to marry each other, that would also be in violation of her beliefs. Mm-hmm. And to force her to do a graphic design web page for such a couple, she would also feel that was equally forced speech. Mm-hmm. So this is not just a thing of having to do with homosexuals. It has to do with her whole panoply of beliefs that she doesn't want to be forced to speak in violation of her beliefs. So the state is portraying this, the newspapers are portraying gay rights versus free speech, conflict of rights, blah, blah, blah. I think our view would be, I think Graham and I would share this view.
Well, let's find out.
Yeah, let's find out, because we're not always going to agree, as I think we're going to see today. I think we would say, the woman has a right to express herself, to engage in free speech, freedom of the press, freedom of whatever medium she wants to be giving forth her ideas on. She should not be forced. She's not a slave. She cannot be just commandeered by the state to be like a puppet or robot of some bureaucrat somewhere. And so the parade of there's always a parade of horribles, as we're going to see, particularly in the election cases coming up in a minute here. So the parade of horribles is what the people on the anti-freedom side say. Oh, if you had freedom, such and such terrible things would happen. So in a sense, what they're saying is, well, if you believe in freedom of assembly, freedom of speech, freedom of the press, and it doesn't let you compel people to do what the state wants and its pet projects, then that's going to mean all civil rights things, like ones having to do with race or other topics, maybe disabilities, I don't know what, would be able to be stood off by somebody saying,
I don't like your race, or I don't like you because
I don't
you're
want to
disabled,
do
so I'm not gonna...
websites for disabled people.
Right.
Okay, I don't even know if that's a right.
That's the alleged...
I don't know if that's a right, but I'm just saying that's the kind of thing. So the
alleged slippery slope.
Right. So the attorneys, exactly, a slippery slope. So the attorneys are trying to distinguish these different things. Anyway, so that's where the case is.
Well, so to be clear, I mean, this woman who is the web designer, her situation is not, for example, like a situation, let's say she owned a photocopy store and somebody brought in their flyer and wanted to photocopy it on her photocopy machine. That's not the kind of thing, because this is rather quite different. This is much more analogous to a portrait artist, for example. Or some other commissioned artist who is asked to create a work of art that has a certain creativity and flair to it that she has to create. She's not just reproducing.
So her attorneys say that her company will, she's basically a customized place. But she might have on sale off-the-shelf web design software. So you could create your own. It's standardized. And the attorneys are saying, well, that's not something that's covered by this. Okay.
Right.
We're really only talking about her customized stuff.
Right, her creative input.
Exactly.
So what's intriguing about this is that apparently the 10th Circuit Court of Appeal accepted the argument on one level that what she's doing really is pure speech. It is expression. But because of the nature of her work, she has a monopoly position. Monopoly position, of course, sounds implausible, but what they mean is not that she's the only wedding web designer that exists, but rather she's the only one who has her particular set of aesthetic skills to be a web designer. And so she's a monopoly of one, but given the fact that she's a monopoly, because nobody else has her particular creative bent, so she's a monopoly of one, and therefore she can't use her monopoly power to refuse customers.
That's like saying Bob Hope is the only Bob Hope.
That's exactly what it's like saying.
He can't negotiate. He has to have 85 clones that are just as good if he's going to fairly negotiate with some vendor or person who wants to hire him or something like that. Or in the marital world, in the courtship world, well, there's only, whoever I'm married to, whoever you're married to, Graham, there's only that one person. That person has some horrifying monopoly on being themselves. And therefore they shouldn't be allowed to be themselves. So I think that's crazy. Not only did we take a long digression to get into the whole theory of monopoly and what.
Well, the courts themselves have taken that digression.
Yes, they have. So I think it, in a sense, exposes the poor arguments there are in the monopoly field. And there are many, many web designers. And you don't have to have a web designer who's next door to you. You can have a web designer
anywhere
who's
in the
Pakistan,
world. Yeah, exactly.
So.
Now, I'm not really thinking about the success of that argument. I don't think the monopoly argument is going to succeed with the U.S. Supreme Court. And in fact, that's a simple way for them to deal with it. They could say that that's the primary argument; it's invalid. But they could go elsewhere. The Supreme Court has been known to develop its own rationale to sustain legislation or other action. I
think commentators who have seen the oral argument, heard the oral argument, think that the court is going to decide for the plaintiff and that she will end up with her freedom.
Yeah,
I think some of the other court cases are more problematic and uncertain as to. So maybe we should go to the next of the fascinating list. Okay,
we will in a minute. But I just wanted to draw an interesting comparison that I've seen in various analyses. If you go back to 1990 to the case Oregon versus Smith, which that was the one where the state of Oregon wouldn't let its employees use peyote. And the employee who was a member of an Indian tribe that used peyote traditionally complained about it. Supreme Court actually sustained state power in that case, including as articulated by Justice Scalia, the late Antonin Scalia, who said that since this is a neutral law of general applicability, that a religious exemption was not appropriate to the state rule against the use of peyote by its employees. Now, it's different and similar to this case, but what strikes me is that the Supreme Court could use, if they wanted to really narrow the holding, they could say it was only a religious liberty exemption, not a freedom of expression or speech exemption. They could go to the religion exemption, but if they
But the briefs filed by the plaintiff are on the speech side. I think, the peyote thing is very bizarre in my opinion. I mean, I wasn't alive then, but I believe during Prohibition, Christian churches could serve wine at communion, even though wine was illegal. Mm-hmm. And there were specific vineyards that were exempt from, being torn up by by Eliot Ness and his friends that were supplying churches for communion. So it's not. I don't want to make it sound too facile. You don't want a church of cannibalism saying, "Okay, we're going to go out and kill people because that's our religion." So we have to be careful.
Yeah,
I think a lot of it has to be considering things that are crimes per se versus state-created crimes that are kind of regulatory of lifestyle. Right. And if those are wrapped up in religion, I think it's understandable that the state would exempt them and the courts would exempt them.
I think that it does make a difference, especially when you deal with the argument about the slippery slope, the domino effect or whatever, the parade of horribles. It really ultimately, I think it does come down to the bearing of one of the key findings in the Masterpiece Cake Shop case, which was that the state of Colorado, same state, could not vilify the beliefs of the cake baker in that case, who did not believe that marriage could even exist between two persons of the same sex.
The thing that upset the state's case was that investigatory work showed that the regulatory body that was behind the supervision of the cake maker had a strong bias against the beliefs.
And he expressed it, right.
Yeah. So I don't think we have that as part. I don't think in this case we have that in the record somewhere.
No, we certainly don't. But what I'm saying is that it's in the background of the situation as the court deals with this, because notwithstanding the claim that there are analogous cases that could constitute a slippery slope, in fact, disagreement about the nature of marriage is really not the same thing as a person who is born black or white or male or female, etc. Where the court really does not want to go to the place where it equates disagreement about the nature of marriage with race bigotry.
It doesn't.
It doesn't want to go there.
But the critics of the plaintiff want to go there.
They do indeed. They do indeed.
So
we'll find out in June. Find out in June. Okay.
I think they can word it so they salvage her rights and freedom of speech, and they don't interfere with state regulation of bigotry, problematic as that also can be.
So I predict 6-3 in her favor, but we'll see. We'll see.
I think that's a pretty good prediction.
Okay, so here's another case the court is dealing with called Moore versus Harper. And this has to do with the creation of, ultimately presidential electors and the existence of districting and so forth. The state of North Carolina was beaten back in its legislature's attempt to be exempt from its own state's Supreme Court review, because the argument goes that in Article 1 of the U.S. Constitution, I have my U.S. Constitution here, which I'll just briefly read. It says, Article 1, Section 4, the times, manners, and places of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. And then again in Article 2 about the presidency, it says, each state shall appoint in such manner as the legislature thereof may direct a number of electors, etc., for president. And so the argument's now being made that where state Supreme Court...
The argument is being made that we should take that at its word.
That's the argument being made, but the implication of that argument is that when a state legislature makes a determination about election matters such as this, that it should not be subject to the judicial review by its own Supreme Court under its own state constitution, but instead should be a free agent due to the U.S. Constitution superseding and preempting the state constitution.
Yeah, and the U.S. Constitution does, on matters that are explicitly laid out, preempt them. I think, by the way, it's not just it's not just North Carolina. New York had a case like this. So the Democrats gerrymandered the seats in the New York State Legislature, and Republicans and good government types said this is terrible gerrymander. They had to redistrict. The redistricting allowed the Republicans to gain 4 seats that they would never have gotten otherwise. In California, we actually have an interesting situation. Our districts are set by an independent districting board. If the Democratic legislature were to design the districts, I can tell you that at least 4 Republican seats would be lost in California also. So this is a very, big deal for politicians. The public can't really fathom what's going on here. The real problem is the following. We saw it in the COVID case. So state Supreme Courts and state attorneys general and governors were suddenly setting the rules for elections, saying, "Oh, this is an emergency. We got medical problems."
Emergency declarations.
All right, so we're going to do something different. And they didn't have the authorization of the state legislature.
Well, except they had prior general authorization for emergency situations.
Yeah, you're being very nice about it. I think they didn't really even. Anyway, so then in the case of North Carolina and other cases, they don't say. They say free speech is being impinged, and
what?
The state Supreme Courts are saying that they can overthrow the decisions of the the lines for voting
drawn by the
free
legislature
speech grounds, and they can just take from wherever they want. I mean, obviously, they're not doing, patents and copyrights or something like that, but they are drawing from other things in the Bill of Rights to take the district lines apart. So I think it was pretty clear, and the Constitution can be amended, that the state legislatures, or at least the state lawmaking process, if you want to be a little more latitudinarian and lax about it. So maybe in a state that has referendum and plebiscite and so forth, they could be doing something that way. But the point is, it needs to be part of the state legislative process and not the courts are not supposed to design the election process.
So what's weird about this, though, Bill, from a political angle, is that typically you've got Republicans who are vindicators of states' rights, and Democrats typically want the federal government to have more, prevailing power. But in this case, the argument by the Republican side, typically Republican at least, is that the federal Constitution preempts what would otherwise be the normal process of a state's self-government with respect to the designing of election laws and districts. That the state should not allow, the states are not allowed to have their own normal legislative and judicial review processes occur, but instead the state legislatures now must be entirely free from their own state constitutions due to the federal Constitution. So we have a suppression of state autonomy in the name of a federal
I wouldn't look at
provision.
it this way.
You wouldn't, okay.
I know, but I love your sense of humor. I think what the way to probably look at it is something like this. Republicans and conservatives and libertarians, more or less, are rule-oriented.
Yes.
Okay?
Mm-hmm.
And so here is a rule, and it's pretty clear-cut. And yes, maybe Republicans see advantage in the fact that a lot of the judiciaries are packed with people that they don't think have even common sense or an ability to read what's right in front of them. They don't like black letter law. They want to get into the penumbras and the
Penumbras, right.
all that stuff. So
Right.
I think that's really, I don't think it's that Republicans or conservatives or libertarians are per se states' rights. I mean, libertarians are for liberty, and then they're
Right.
trying to construct things consistent with liberty.
But constitutional conservatives are usually in favor of greater semi-autonomy for the states.
I just think, it's like saying, oh, the president is supposed to be so many years old, right? But the state of North Carolina wants to have its electors pledged to somebody who's 20 years old for president. Shouldn't we let the states decide who their electors can cast votes for? And if they want to do something, it's old-fashioned to say that you can't be 20 years old and elected president of the United States.
Right. That, obviously,
I'm
that's
sorry,
a bad argument.
It says in the Constitution that you have to be 35 or whatever it is. I believe that's what it is. And so, it's straightforward.
Well, but listen, here's another angle on this bill.
Okay.
I'll let it drop in a minute, but one more go. So if you look at the enumeration of powers
All right.
in the federal Constitution, what we're
Exactly.
talking about here is that the federal Constitution says that the state legislatures have this power.
Right.
And they should exercise it. But of course, elsewhere, let's say in Article 1, Section 8, it says Congress shall have power to, and then it lays out all these different things that Congress shall have power to do. So in Article 1, it lays out all the things that Congress shall have power to do. But the fact that the federal Constitution in Article 1, Section 8 enumerates these powers of Congress doesn't exempt Congress from judicial review. It doesn't eliminate the fact that the president has to sign the bills for the thing to pass into law, et cetera. So why should it be different with the state legislatures? Why should they and they alone, unlike the federal Congress, have an enumerated power that's completely exempt from their own state judicial review processes? That's my argument. Can you undo me?
I should introduce you to L. Brent Bozell Sr., who thought that courts had slightly run away with their review powers. But anyway, I think this is too complicated to get into, but I take it that you have a good point.
Okay, let's talk about another issue before the court, which is apparently the Supreme Court has agreed that it will hear the case on whether or not President Biden had the power as president by declaring a national health emergency to forgive, $400 billion worth of student debt. The Supreme Court has not yet ruled on it, and apparently they will. But interestingly, the court could have allowed the debt forgiveness process to continue
Right.
Well, they
But
heard
it
the case,
isn't.
but they didn't. But they
And
didn't.
that's
Yeah.
that's a sign.
That's a big sign.
That's a sign that they're not going to approve it. Now, the interesting problem here is the issue of standing.
Right.
So, in order for a case to come to the Supreme Court, to come into the court, there has to be somebody who's injured or is adversely affected and so forth. So here are these people getting, and it can't just be I'm a taxpayer and I'm,
Right.
They say that's too diluted. So you have to be somehow somebody who's adversely affected by this in order to appeal to the courts for a remedy. So let's say you have some kind of state plan and it's subsidized by the feds, but the new formula affects that state scholarship plan or something like that. That kind of thing has brought states' attorney generals into this case.
Right.
And so anyway, there are two cases that have been proceeding along. It looks again like just from these indications, sort of straws in the wind, like them not allowing an injunction that would keep it going while the courts are deliberating, that the majority of the court does not think that the Biden people, I mean, this would be amazing if they could, by executive action, spend, all
$400 billion by executive action.
Right.
It's
So
really,
that would be essentially the end of our semi-constitutional republic.
it would, because it would mean that all you'd have to do is declare an emergency.
And clearly, anyway, the emergency is over. And clearly,
President Biden said the pandemic is over. So, but the pandemic is not over for purposes of debt forgiveness.
right.
So
And,
it's confusing. Which is it?
well, I mean, the pandemic is not over. We're probably going to have some version of it for the rest of our lives, or
Right.
the rest of everybody's lives. It's going to presumably attenuate in severity, but probably gain in contagiousness.
I mean, you can't say, for example, that if there are viruses around, you can't have constitutional government anymore.
Yeah,
That's not a good argument.
That's really the reductio ad absurdum of this whole case. And I mean, it's also very weird. This was a statute that was intended to help out military people who were having problems with mortgages and things like that. They were, and it was extended into this COVID situation, I don't think unreasonably. And then now it's just like growing like topsy. It's going to potentially can take over the entire budgeting process of the United States. So I think assuming, it looks like the standing thing will be all right. Assuming the standing thing is agreed to by the court, it looks like they will say that this is a step too far on the part of the
They might well. I mean, it does have something in common with something that President Trump did. And I was reminded of this by Ilya Somin on the Volokh conspiracy, pointed out that President Trump used emergency powers to divert lots of military funds to build a border wall.
building the wall. It's exactly the same thing.
It's the same thing.
He should not have done that either.
Yeah, I totally agree.
Let it be fully acknowledged that we have no fear in criticizing Republicans as well as Democrats.
That's right. Absolutely. President Trump was wrong when he did that. But, the thing is that there are millions of students who have been notified of the, debt forgiveness and who have been actually gone through the process, millions of them, to inscribe themselves in the debt forgiveness, the portal through the federal government's website thing. And so it's possible the court could say, well, this was an improper use of executive emergency powers, but since citizens innocently have been given the expectation, we have to let that particular thing proceed, but this must never happen again. Could that be done by the court?
I don't think so. We're not entitled to our expectations. Many people thought FTX was going to keep going up, up, up. Many people thought IBM was going to, or General Motors, or General Electric, or Exxon or whatever, we're going to constantly be doing great.
Right.
Many people thought, the United States could never be defeated in a war. Well, I think objectively we lost the Vietnam War.
Yeah,
so,
well, maybe the Afghan.
Yeah, or the Afghan War. So the point is, you can't really be morally entitled to your expectations. Now, that doesn't mean politicians can't try and expand people's expectations, trade on people's expectations, whip up people based on their expectations. And the Supreme Court, although it's supposed to be part of the rule of law, might wrongly defer to expectations. But I can't really see
I don't think
that they could say, I mean, these people all signed agreements that they were going to pay this money back. Why don't we have that be the expectation?
Right. But you've got to admit, the politics of this are totally brilliant, because even if the Supreme Court strikes it down.
Right. It's either the Republican governors that have done this to you, or the Republican attorney generals, or the Republican members of the Supreme Court.
Millions of college students.
We want to give you good stuff, we Democrats.
The Democrats tried to give us this debt forgiveness, but the darn Republicans stood in the way and are so stingy. So even if the thing goes down in flames at the U.S. Supreme Court, it's a huge win politically, because millions of college students will remember who blocked their loan forgiveness.
Well, you can even put it another way. The Democrats were desperate to get young people to vote in the midterms. So they announced this forgiveness plan during the run-up to the midterms.
Right.
Close enough to the midterms that the courts could not rule decisively that this was unconstitutional until afterwards. So they got the benefit of the youth vote, assuming that the youth vote can be bought and sold this way. I do think it's not too difficult to explain to somebody we don't really have a political system. They don't have to be super well educated to explain to them we don't really have a political system where whatever the king or the president wants is what happens.
Right.
Certainly when it comes to hundreds of billions of dollars. And so I think
that's kind of obvious. People should get that.
I think people can understand that.
Yeah, I think so.
They might still, wish that they'd had a cornucopia of benefits poured down on them, but I think you can still fairly easily. It's not like trying to explain the Federal Reserve System to
That's
to
really
explain
hard.
what's wrong here. Right. Okay.
Since you're an education expert, do you want to comment on this one last thing that is on the court's docket regarding the Harvard case and affirmative action? I mean, is Harvard as bad as it seems? It looks like, from all the stuff I've read about the case, that Harvard really sets out deliberately to minimize the number of Asians, and that many Asian American applicants try their level best to make themselves seem less Asian so they can get into Harvard. This is rank racial sorting, or am I missing something?
Well, I think it's clear from what came out in the course of this that, if you're Asian American, you don't put down that you're good at chess or that you've learned Mandarin or you born into a family where you know Mandarin, or even check what race you are.
Because it'll count against you.
Yeah. And I think that's an ugly situation. Now, there's a broader problem, which is, okay, we can easily see for University of North Carolina, which is a state university, that they shouldn't be engaged in racial sorting like this. However, it's possible that a private university could do strange things. Like, it could be a Brethren religious group university, and they might give preference to Brethren, or it could be a Catholic university.
But that would be sort of straightforward and honest.
Okay, I know they're being tricky and all that about this, but some people would say that admissions is a very strange process. Essentially, these universities have a very scarce commodity, their college experience and their diploma, and the various signals and experiences that this awards. And they control the border of going on campus and getting this experience and this certificate. So perhaps if they want to put great football quarterbacks in their classes, okay, maybe they should have a right to do that. And so some of this might fall under that. So it's interesting to see Richard Epstein, the famous legal scholar and classical liberal. So when this case first started coming out, he was sort of arguing that what I just said, that the universities, the private universities, have a right to control their boundaries and who's in the classroom, who their professors are encountering, and so forth. And as time has gone on, and as the egregiousness of what Harvard has been doing, he has kind of flipped to saying this is really an equal protection
right,
thing.
Isn't that fascinating?
These universities have tons of public money in them, even when they're private. And it's outrageous for the level of this racial attentiveness and sensibility that
so Epstein's view has changed.
I think it has. I may have misread him, but my recollection is pretty firm. I didn't double check it before we did this, but I quite sure I recommend him being at the beginning on one side and having evolved over time.
Well, you know, the millions of dollars that are received by these private universities from the federal treasury, I mean, it's hard to say that there's a bright line distinguishing public from private, except for the a small handful of schools, colleges, which don't take federal money. I can see their point, but all the rest, including Harvard, and millions of dollars,
well,
how private are they?
It's a complicated problem. So yes, there's a handful like Hillsdale and Grove City that don't take any federal money, meaning they don't even take federal scholarship money. Right. But maybe there's a difference between Harvard and Swarthmore. With Swarthmore probably not having very much research money, whereas Stanford or Harvard, they'd have to charge twice as much tuition and various things in order to support the same kind of research without the federal money. So anyway, it's complicated. I think we've laid it out.
We've laid it out.
But I think Harvard and University of North Carolina are going to lose because
I think so too.
The discovery has been of such. So one of the things. So we're talking about chess and all this stuff. One of the ways they do this is they have these academic ratings of people based on standardized test scores and grade point averages and things like that, and then they have another category. They have other multiple categories, but another big category is kind of a personality thing.
Yes.
So it turns out that all Asians, according to these admissions officers, are selfish and not gregarious and don't want to improve the world. They just care about themselves and so forth.
They're characterologically
deficient. They're not well-rounded and so forth.
Good grief.
So it's interesting because the whole well-rounded thing came, which is certainly around when I was applying to college many centuries ago, was devised as a way to block Jews from getting in large numbers into the Ivy League. So they would evaluate the Jews as being too studious and not well-rounded enough, not clubbable, whatever.
Right.
So we're seeing a somewhat different version of that with the Asians.
So what's interesting, Bill, this question of whether these private universities like Harvard, whether they are in fact private enough to be able to discriminate with glee, is parallel to the question of the big social media companies. So people point out that, Twitter and Facebook, they're private companies, and so if they want to suppress certain news stories and favor others to influence the political world, they are private actors and they should be free to do whatever they want to do. But with Elon Musk's accession to the top of Twitter and his big document dump, it's really shed light on the inner activities of a place like Twitter. To reveal that maybe not only do they get lots of money from the federal government, but even aside from that, they have a lot of receptivity, shall we say, to influence and suggestion and pressure from politicians in their decision making, making them look a lot less like simply private speech actors and much more like semi-agents of government or political parties. So what do you think about this document dump from Elon Musk?
Well, first of all, it's fascinating. It's just really interesting. You laid it out quite well. I think my inclination had been, and not everyone at Independent at various times had agreed with this, but I thought by and large they were private platforms, and the people who were posting their own material on these platforms were something that these platform editors could edit or moderate or something like that. Mm-hmm. But they weren't they were just doing that as part of their public service, and no one had a right to be on there, and the government really shouldn't be interfering with it because it was
that was a nice clean argument.
Right. Now, of course, even at that time, I knew that some of these companies had contracts with the Defense Department and other things that clouded this.
Right.
But we found out, exactly as you've said, that the FBI was holding meetings with at least Facebook and Twitter weekly in the run-up to the last election, that they were, by the last presidential election, that they were telling, so it's even more strange. So the FBI received the Hunter laptop like 2019, okay?
Right.
So
which everyone across the spectrum now has admitted really is Hunter's laptop.
But they had it, okay? And it was in the hands of this guy, Timothy Thibault, who was later fired by the FBI for being too fanatically pro-Biden and pro-Democratic. But anyway, so he had it, and he basically, we don't know exactly what he did, but he either sidelined it, put it away in some box somewhere, or he looked into it and he found out that this is something that needs to never really be paid attention to for reasons of what is in it. So they also were monitoring Bo Belinsky, a former partner of the Bidens, and they were monitoring Rudy Giuliani. So they were all going back and forth about the Post, this New York Post, long time, 5th biggest newspaper in the United States. We're going to do a detailed story on the contents of this. And so then they proceed to give these cautionary warnings. There's about to be a Russian hacked dump of false or illegal information, be on the alert, et cetera, et cetera. So as Andrew McCarthy, who's a very good journalist on legal matters.
He's anatomized this brilliantly.
Right, federal prosecutor. So he says, look, you're not going to find a smoking gun. You're not going to find, well, we're not completely sure. There may have been some smoking guns that James Baker edited and threw away before he left Twitter. But anyway, we'll get to that in 1 second. But McCarthy says you're not going to see a smoking gun. These are all sophisticated players. They know if they say, we're forbidding you to post anything having to do with Hunter Biden, they'll get in a lot of trouble. So they do it with a wink and a nod. They do it with caution is warranted, is the phrase they actually use. So they had these regular meetings, and, they signaled to these people, it's a threat, it's intimidation, it's pressure that they're putting on these media. You're going to be in big trouble if you push this.
Now, Mark Zuckerberg even admitted in his conversation with Joe Rogan that while the laptop, Hunter Biden's laptop, was not explicitly mentioned, he understood the caution to apply to it.
And the main caution comes, and then, like the next day, they get this story coming out. So it's not the next day, but it's right afterwards.
Right.
So anyway, I think it's clear that the FBI seriously overstepped its bounds, and it kind of turned into commandeering these platforms, and then we now have a bad situation. But the good news is private enterprise allowed Twitter to be purchased by somebody who didn't agree with this.
That's right.
This is making the pro-control establishment go apoplectic.
Oh, it drives them nuts.
And they say, oh, hate is going everywhere. There's different measures of that. There's measures that say, no, it's actually better now on Twitter. They say the bot numbers, so these are robotic posters, reposters, that's gone way down. There's a bunch of measures that indicate Twitter is actually a better place, but it's in the eye of the beholder to some extent. So some people find it horrible, and but I think it's good that private enterprise showed that an alternative could come into existence, and will now compete in their own ways with Google and particularly Facebook.
Right.
But then there's also things like Truth Social and Reddit and all these other things out there, Rumble, and it's more competitive than people realize, and Musk showed that it's really quite competitive.
Now, some people think that, well, what we're arguing about here is whether it was appropriate to suppress sexy pictures from Hunter Biden's laptop.
I actually was watching, I know this might frighten some of our viewers here, but I was watching MSNBC, and Lawrence O'Donnell argued that the main point of Twitter's activity was to suppress pictures of Hunter Biden in the nude, and then everything else was totally ancillary.
Yeah, I mean, I don't think it's great that there were those pictures and whatever, but I don't think that's the reason that people are concerned about this.
Right. And by the way, I don't think Twitter under Elon Musk is going to be presenting full frontal pictures of,
no, please don't.
Hunter Biden. Yeah, please don't. Spare us. Actually, the interesting thing is there are tens of thousands of child pornography postings on Jack Dorsey era Twitter.
Oof.
And Elon Musk is scrubbing those. So he's systematically reducing that.
But the real issue was the other stuff.
It's not that he's not going to moderate. He's just
right. He says
going
he will.
to allow. He says he's going to moderate, but in general, the kind of controversial speech and topics, he's going to be much more allowing of it. And it was the other stuff, the stuff that suggests that President Biden and the whole Biden family was involved in a vast influence peddling business, and maybe substantial amounts of money was going even to the president himself, certainly to his brothers, certainly to his
Meetings
son.
were actually held that Joe Biden said never happened.
Yes.
These are the reasons why the contents of the laptop were really provocative.
And it's also the reason why there are several opinion polls, and it's so counterfactual, it's really hard to say what weight to put on it. But there are a number of things that say up to 9% of the voters would have switched. And I can tell you, it would have meant that in the swing states, Trump would have won. Now,
I mean, if so, that just shows you the power of this kind of content control.
I mean.
And
we
again,
could say a lot of things. Maybe the Trump organization's tax problems coming out before the election might have swayed. We don't really know.
We don't know.
Elections. Anyway,
and there was evidence that the Trump people sometimes asked for unfavorable things to be taken down.
Yeah.
Yeah, that was
but
much less.
They didn't. They the thing is, because of the politics of the staff of Twitter, overwhelmingly. So Elon Musk posted, he said, why am I not getting requests from conservatives to restore things, or, no, what? I said it completely wrong. Why am I not getting requests from liberals and progressives to restore our group or our status on Twitter? Because they weren't
they weren't cut off.
They weren't canceled. It was only the conservatives and libertarians and other.
And this whole thing that's been revealed now with Elon Musk's revelation of the Twitter background, it actually sheds really important light on a major confusion, I think, in American politics today, which is, was the 2020 election stolen or not stolen? So the stuff we're talking about now has nothing to do with some legitimate votes not being counted, or other, illegitimate votes being counted. It has nothing to do with vote counting.
Right.
It has entirely to do with the information environment around the election, which
Right.
was manipulated on
It was.
purpose by political actors, including governmental actors, through social media. Now, that's not the same thing as saying fraudulent voting. There's nothing to do
That's
with
right.
fraudulent voting, but it has a lot to do with the environment, which is a very different issue. Sometimes people say, "Oh, the election was stolen." Well, apparently not. But actually,
Right.
there is something to be said about the distortions of the information environment.
Well, I would put it, without disagreeing with you, I would say, if it were stolen, we really wouldn't know because, the ballots are cast. So let's say 11 dead people are former inhabitants of an apartment house vote. Okay, they voted. It was illegal because they're not living there and they maybe
Right.
voted from another place or they're dead. Now, okay, the votes are in. So now how are you going to
can't-
tell?
we don't
And
know
how
how
are you
they
going to tell
voted.
which way they were going to vote?
Yeah, that's
so
true.
the part of the problem with journalists saying, I mean, they have a basis for saying this, but for saying, oh, there's no proven cases of major election fraud. Well, that's because you can't find them. It's not really feasible.
And
now
the
we
thing
did
is-
have an interesting case in I want to say in Florida or North Carolina. Anyway, there was this guy. Yeah, it's in North Carolina. He's running for the state lower house, and he's a felon. So he's on probation from a felon. He stole $35,000 or something, embezzlement. So he's been running for state assembly, and he strongly makes the case that 2020, 2022 elections are stolen, and all. But he's not in that state. He's not supposed to vote. Felons are not supposed to vote. He's voted the last 9 elections. So
Wow.
this is a humorous sidelight to this whole topic.
Right. But I would say that nothing that was revealed through the latest Twitter revelations could in any way be used to justify, as one recent presidential candidate has alleged, that since we find irregularities, we should terminate parts of the Constitution, as one presidential candidate really said. None of it justifies that.
Yeah, I think that's certainly a kind of common sense way to understand what he said. There are people who say that he said the fraud empowers violating the Constitution, violating the laws, whatever. He worded it in
that's
some
a very different meaning then, isn't it?
Yeah, I know, but he worded it in a very half-assed way. And let's say he meant the way you
Took it.
laid it out.
Yeah.
He says a lot of things. He doesn't necessarily follow through on all those things, and the people around him don't necessarily go along with them either. So, so you can have a king who says, "Who will rid me of this meddlesome man," referring to Thomas à Becket. Now, maybe nobody will do anything about it. Or maybe they will. They'll think, "Wow, I'm going to get in good with the king. I'll go kill this guy." Archbishop of Canterbury back in the Middle Ages. Well, a lot of politicians in their private boudoir, and Trump has no ego filter or anything. He just spouts out what he's thinking at the time. It's funny. Most presidents are very reticent, and we don't really know what's on their mind.
Right.
We've seen the good and the bad of the opposite. Trump is
We have seen the opposite for sure.
Yeah. And so all these people that would say, "Oh, this president, that president never holds a press conference, never, we'd have no idea what's on his mind, what he's thinking." With Trump, we kind of know too much of what's on his mind.
Right.
It's kind of an interesting
TMI. TMI.
exception. So anyway, he said something, whether he was saying that this that bad stuff pushed the whole system in a bad way, or whether he was saying this or other things were so egregious that the normal constitutional procedures ought to not be followed. Certainly, you don't go suspending the Constitution over this. You try and work within the Constitution
that's right.
to address the problems.
Yeah. So let's talk briefly, we're kind of running short on our time here, but let's talk briefly about some other big money, big politics issues, particularly around the collapse of the crypto exchange created by Sam Bankman-Fried. What's going on there?
A lot of funny things. Well, so he personally gave $40 million to Democratic congressional candidates, and that's a lot, by the way.
That's
for
a whole
single
lot.
donor. And so he was very close to lots of. There's lots of pictures. If you're traveling in donor circles, I have zillions of pictures of me with politicians. Not that I give very much money, but I hang out around those circles.
You have big ideas, not big money.
That's right. I'm an idea man. But and so the donors like to talk to me too. But anyway, so he was a big donor, and this company that was kind of a Ponzi scheme, and he had an attached research arm that was also acting as a kind of bank, and it was a very peculiar Rube Goldberg operation. He didn't really know where the money was. The people that have come in to manage the bankruptcies, they had never seen a more disorganized company ever.
Thousands of people have lost millions of dollars each.
That's right. That's right. But I think it's just best understood as a Ponzi scheme. Mm-hmm. Anyway, one of the fascinating things is he was a pal of Maxine Waters, who is the head of the Senate Financial Services
House
Financial Services Committee.
Right.
And so, this is exactly the area of jurisdiction for that committee. And normally you would subpoena the person right away. Okay, come in. We want to talk to you right now. And you'd even think the Democrats are kind of lame duck in the House right now. They'd want to get in there and, while they have control, do it their way before the Republicans take over and do it the way the Democrats don't want it done. But she won't issue a subpoena to him. She says, well, we urge him to come.
Wow.
Now, it's more interesting than this. So her husband is a former U.S. ambassador to the Bahamas. And
that's where Bankman-Fried is hanging out.
That's right. And so there's an important Bahamas politician named Allison Maynard Gibson. This is a female, was a lawyer also for the crypto exchange and FTX. The lawyer's daughter was the director for social responsibility for FTX. Waters' husband, this ambassador, and Waters herself have stayed in Allison Maynard Gibson's home.
Oh my.
So Waters, who not only wants to not have to give a subpoena to him, to Sam Bankman-Fried, but she's entangled with the sleazy Bahamas politics that Waters herself is entangled in. So I think the lesson or the point of recounting this is that we see a kind of progressivism. So Waters is very left-wing. She's one of the most progressive members of Congress. If I'm, in a sense, trying to superimpose rationality on her, because she's kind of says some unexpected, strange things.
She sure does.
Various times. But anyway, if you can give her coherence, she's very left-wing. So here we have progressivism, but it amounts in practice to cronyism, to picking favorites and protecting them and giving them special privileges. So I think that's a kind of a lesson to how this is emerging.
And Bankman-Fried,
and the news media is also kind of still lionizing the guy. It's sort
strange,
of amazing.
Yeah. I mean, he apparently made much of what was his philosophy. He called it effective altruism or effective philanthropy, something like that. And
effective
he said,
altruism.
Effective altruism, yeah. And he said in some of the comments initially after this big Ponzi scheme broke up, he admitted that he and others like him would just mouth what he
Right.
called shibboleths of
Exactly.
social
Yeah.
justice, such as climate change and whatnot,
Right,
because
right.
everybody would go along with them if they mouthed the shibboleths.
And it would be a smokescreen so that he was somewhat immunized from
Right.
people looking into him. Oh, he's a good guy.
He's a good
But
guy
I
because he supports international governmental action in response to
Right.
climate change or whatever.
Right. And no, that in particular, that was one of his biggest causes. I do think so. Effective altruism is not original with him by any means.
No,
The
no.
idea, and I don't think it's in principle a bad idea. Now,
Well,
obviously,
the concept is good.
right, because many people give money in ways that are counterproductive or
Right, mhm.
ineffective or however you want to look at it. I think it's good to look into, if you're being philanthropic, if you're being beneficial to help other people, to look into what are the effects likely to be. Now, of course, just like social planning, you can't really predict this, but I mean, I think it's worthwhile to look into it. But anyway, it provided a smokescreen for him, and it provided him with a talking point, and he was an amazing con man. I think that's how we have to really leave
yeah.
it.
It's kind of stunning because, it has a lot of the characters of other great busts in the history
Yeah.
of American business.
Right.
And yet, he's not being, deprecated the way the horrible robber barons were or whatever.
He's not
earlier.
getting the Sam Insel treatment.
No, he's getting a kind of a pass in terms of
That's right.
the coverage, and it doesn't seem right.
Well-
So, Bill, in the last segment here, I think you want to shed a little light, or could, on what's happening with negotiations with Ukraine. Is there
Yeah.
any possibility that this conflict can be ended through negotiation, or do we have to keep pushing until all-out conflict?
Well, I mean, I think in the short run, they're not going to resolve it through negotiation. So the interesting thing that happened since we last talked to our viewers here was President Macron of France went and met with various people and said that in order to end this, in order to come to peace terms, there needs to be a strategic architecture, a look to the future in this region. And he said Ukrainians understandably want protections of various sorts, but also Russia has security interests. And Macron was sort of saying this is not just a whim of Vladimir Putin, this is the Russian state having interests in this area historically, and that any peace, his aide, his spokesperson said, look, Russia's going to be around, whatever. And so some terms of peace have to address Russia's security interests.
That's
and so
right.
Some that were enumerated were weapons right next door. In other words, like one of the supposed boogeymen was that maybe Sevastopol, which is in the Crimea and had been part of Ukraine until Russia took it over in 2014. But what if that had been turned into a NATO base? Or what if
Right.
NATO had missile launchers all along the Russian border? Now, in truth, you don't need to have them by the border. I mean,
Right.
when we had the human missile crisis and we were saying, oh, we were much worse threatened, but the Russians, you can be, in those days, you could be more accurate with a land-based missile than from a submarine. But the Russians could have had tons of submarines off the U.S. coast based in Cuba, and presumably they today have a missile-bearing submarines off our coast. So, but anyway, it looks bad to the Russians to have
Right.
NATO, which is already in the Balkans and it's in Poland, and it might go into Georgia. And so the point that Macron was making was this needs to be addressed. And maybe we're not going to make everybody happy, but at least we might make some progress. And that might be a way to bring to peace. But immediately, the Ukrainians said no, The only person who needs security protection is us. If it were up to us, we'd rather see Russia disarmed. The whole Russian leadership should be given Nuremberg war crimes trials.
Wow.
And no, I'm not making this up. That's exactly what they said.
I know.
And so the only strategic protection that's needed is to guard against further aggression from Russia. Now, I'm understanding where they're coming from. Both sides think that further military action can help them in their cause. The Russians complain that the U.S. said, well, what is Russia doing to try to come to some modus vivendi here? The Russians said, well, we don't want to even hear from the Americans because they won't recognize our incorporation of these eastern Ukrainian territories, Kherson, Donetsk, so forth. And of course, the point of the U.S. is that we don't think that Russia is entitled to have those. Now, Ludwig von Mises, were we able to bring him back from the dead? He, after all, was born in Ukraine.
Oh, I didn't know that.
Yeah, Lemberg. It was called Lemberg, but now it's Lviv. So anyway, he would have argued that they should have had, long ago, they should have had impartial plebiscites in each little village in eastern Ukraine. The way they had in Mamel. Do you want to be part of Russia or do you want to be part of Lithuania back at the end of World War I? The Russians and Ukrainians should have done that. And then they could have settled this. They might still have had a war, but it would have looked completely different for, let's say, Ukraine to be invading a village that wanted to be in Russia, or Russia to be invading a village that wanted to be in Ukraine. And it clearly said so under a UN plebiscite or something like that. And it was we could still try and do it today, but it would be difficult because so many people have fled. These areas are now very depopulated.
And in some cases, the Russians actually deported residents from the ground deeper into Russia.
They have. And children who may not be that easy to find.
So you're saying Mises would have recommended a vote to which country you want to be in?
Yeah, exactly. And I think that makes a lot of sense. And there was a Russian international relations guy that argued for that at the time of the breakup of the Soviet Union. There are some classical liberals today that are still arguing that that's the way to address this. Even Ivan Eland has now written something.
He has, yes, indeed, right.
So I don't know if we still have time, but I wanted to tell one horrifying anecdote from education world where I...
Okay. We'll give you the last word today, Bill.
Okay, thank you, sir. So it looks like the California State University system, which for 6 years has been contemplating the idea of saying that high school students should take 4 years of math or science before they try and go to State University in California. They're going to back away from this because it's racist to expect that kids will take 4 years of math or science. Now, it's interesting. This is, in a sense, this is ridiculous because even when they were talking about doing this, they were saying, well, let's have these cinch classes, these fake, not difficult classes that count for this. Or they were reassuring people, oh, this can be physics for babies or whatever it is. But the key thing, so Ze'ev Vorman and I wrote a column in 2019 for Independent Institute. It was published in the Orange County Register. And we pointed out that the real thing was not this 4 years thing. The real thing was that they have stopped giving people placement exams when they come in. They don't say, okay, how much math do you really know? You don't know enough. You got to go into remediation. They've stopped doing that. So the 4 year thing was actually a kind of fallback to disguise that they were.
You could hide behind that a lot better.
Yeah, but now they're not even hiding behind that. So once again, the world is going to hell in a handbasket, but It's the Christmas season, so I wish all our listeners the very merriest Christmas season.
We do, very much so, and happy Hanukkah and wonderful holidays to you all. And if you want some more in-depth analysis of some of these and other issues, as always, I invite our friends to go to independent.org online, and you'll find a lot of serious investigation of these things that takes the evidence seriously and that has a big concern for individual liberty. That's the hallmark of our work. Please do visit us at independent.org. Thank you, Bill Evers, for joining us today.
Thank you, Graham.
And thanks to all of our friends. We'll see you next time on Independent Outlook. Take care.